Strict liability. Animals, abnormally dangerous activities, products, and defenses. Comprehensive bar examination study outline and essay analysis framework. Part 1. Key terms and legal definitions. General strict liability concepts. Strict liability. Liability without fault, a doctrine holding a defendant legally responsible for physical injuries or property damages regardless of intent, negligence, or the implementation of reasonable precautions. Due care. The degree of care and caution expected of a reasonably prudent person under similar circumstances. In strict liability actions, proving due care does not shield a defendant from legal responsibility. Scope of risk. The legal requirement that the harm suffered by the plaintiff must stem directly from the specific hazard or dangerous propensity that makes the animal, activity, or product inherently dangerous. Prima facie case. The foundational evidence and legal elements necessary to sustain a cause of action and survive a motion for a directed verdict. Animal liability terminology. Wild animal. A species of animal not historically domesticated for service, utility, or companionship to human beings. Domestic animal. A species traditionally devoted to human service, utility, or companionship, including dogs, cats, horses, and cattle. Known dangerous propensity rule. A doctrine providing that an owner of a domestic animal becomes strictly liable for harm only after acquiring actual or constructive notice that the specific animal possesses vicious or atypical dangerous tendencies. One-bite rule. The traditional common law framework under which an owner of a domestic animal escapes strict liability for an initial attack unless prior behavior put the owner on notice of dangerous propensities. Trespassing livestock. Farm animals that stray onto private real property, subjecting the possessor to strict liability for foreseeable land or crop damage. Fencing out laws. Statutory enactments requiring property owners to build and maintain boundary fences to exclude intruding livestock, creating an exception to absolute livestock trespass liability. Abnormally dangerous activity terminology. Abnormally dangerous activity. An extraordinary operation involving a high risk of severe harm that cannot be eliminated through reasonable care, subjecting the actor to absolute liability. Ultra-hazardous activity. The traditional common law designation for an activity posing extreme risks incapable of mitigation through reasonable care. Common usage exception. A defense establishing that if an activity is customary, ordinary, or widely conducted by the general public in the locality, strict liability does not apply. Question of law. An issue decided exclusively by the trial judge rather than the jury. The determination of whether an activity qualifies as abnormally dangerous is a question of law. Products liability terminology. Commercial seller. An entity regularly engaged in the business of manufacturing, distributing, wholesaling, or retailing goods of the type in question. Manufacturing defect. A physical flaw occurring when a product unit departs from its intended design or safety specifications due to an assembly error. Design defect. A systemic flaw occurring when an entire product line is manufactured as intended, yet the underlying design creates an unreasonable risk of injury. Consumer expectations test. A design defect standard evaluating whether a product fails to perform as safely as an ordinary consumer would expect when used in an intended or reasonably foreseeable manner. Risk utility test. A design defect standard balancing the inherent dangers of a design against its technical and economic utility, requiring proof of a feasible reasonable alternative design. Reasonable alternative design. A practical, economically feasible design modification that would have prevented or reduced the harm without substantially impairing product utility. Warning defect. Failure to warn a product flaw stemming from the omission of clear instructions or prominent warnings regarding non-obvious hazards foreseeable to the manufacturer. Learned intermediary rule. A doctrine in pharmaceutical litigation providing that drug manufacturers satisfy their duty to warn by informing prescribing physicians rather than end consumers. Puffery. Generalized commercial statements, sales talk, or subjective opinions that do not create enforceable express warranties or material misrepresentations. Express warranty. An affirmation of fact, promise, or description made by a seller relating to goods that becomes part of the basis of the bargain under UCC Section 2 to 313. Implied warranty of merchantability. A statutory warranty under UCC Section 2 to 314 guaranteeing that goods sold by a merchant are fit for the ordinary purposes for which such goods are used. Implied warranty of fitness for a particular purpose. A statutory warranty under UCC Section 2 to 315 arising when a buyer relies on a seller's specialized expertise to select goods for a specific purpose known to the seller. Defenses terminology. Assumption of risk. An affirmative defense establishing that the plaintiff knew of the specific dangerous condition and voluntarily chose to encounter it. Comparative fault. A modern doctrine reducing a plaintiff's financial recovery proportionally based on their assigned percentage of negligence. Unforeseeable product misuse. An extraordinary or bizarre use of a product that a manufacturer could not reasonably anticipate, serving as a complete defense by cutting off legal causation. Substantial alteration. Post-distribution modifications made to a product that cut off proximate cause if the modification directly produced the harm. Disclaimer: contractual terms designed to limit or eliminate warranty protections. Contractual disclaimers of strict liability for personal physical injury are void as against public policy. Part 2. Strict liability for animals. Black letter law. Possessors of wild animals are strictly liable for injuries caused by dangerous propensities typical of the species. Owners of domestic animals face strict liability only when possessing actual or constructive knowledge of the animal's dangerous propensities abnormal to its class. Livestock owners incur strict liability for foreseeable property damage caused by trespassing animals. Core elements: ownership or control. The defendant owned, kept, or harbored the animal. Classification and knowledge. Wild animals. Liability attaches automatically based on species characteristics. Domestic animals. The plaintiff must establish that the owner knew or had reason to know of a dangerous propensity atypical of its breed. Causation. The harm resulted directly from the dangerous propensity or from fear induced by an escaped wild animal. Foreseeable hazard. The harm fell within the zone of risk created by the animal's presence or escape. Subclassifications and special rules. Wild animals. Animals not historically domesticated for human utility, such as lions, bears, or venomous reptiles. Conscientious confinement or taming efforts do not shield the owner from strict liability. Domestic animals. Animals traditionally domesticated for human companionship or service, such as dogs, cats, horses, or cattle. Under the traditional rule, liability arises only after the owner receives notice of prior vicious acts. Trespassing livestock. Owners are strictly liable for property damage when livestock strays onto private land. Statutory fencing out exceptions require landowners to maintain adequate fences to bar recovery. Zoos and public duty exceptions. Statutory duties or public mandates often substitute standard negligence for strict liability when public zoos or research institutions keep wild animals. MBE application and exam tips. If an escaped wild animal causes a bystander to panic and suffer injury while fleeing, strict liability applies because flight is a foreseeable reaction to a wild animal. Conversely, if a domestic dog bites a visitor for the first time without prior signs of aggression, strict liability fails and the plaintiff must prove negligence. Trespassers injured by wild or domestic animals generally cannot recover under strict liability unless the landowner maintained a vicious animal intentionally to harm intruders. Attack statements. An owner of a wild animal is strictly liable for harm resulting from dangerous propensities characteristic of that species, regardless of the degree of care exercised. An owner of a domestic animal is not strictly liable for harm caused by the animal unless the owner possessed actual or constructive knowledge of the animal's dangerous propensities abnormal to its breed. Part 3. Strict liability for abnormally dangerous activities. Black letter law. A party carrying on an abnormally dangerous activity is subject to strict liability for harm to person or property resulting from the activity, even if the actor exercised the utmost care to prevent injury. Core elements. Abnormally dangerous classification. The activity satisfies the restatement factors evaluating risk and community appropriateness. Unavoidable danger. The inherent risk cannot be eliminated through the exercise of reasonable care. Causation. The activity served as the factual and proximate cause of the plaintiff's damages. Scope of risk. The harm resulted from the exact hazard that rendered the activity abnormally dangerous. Restatement 6-factor test. Courts weigh 6 factors as a matter of law. High degree of risk of physical harm to persons or property. Likelihood that any resulting harm will be severe. Inability to eliminate the risk through the exercise of reasonable care. Extent to which the activity is not a matter of common usage. Inappropriateness of the activity to the location where it is conducted. Extent to which the activity's value to the community is outweighed by its inherent danger. Recognized activities and limitations. Qualifying activities: commercial blasting, storage of high explosives, crop dusting, bulk chemical transportation, and nuclear facility operations. Excluded activities: driving automobiles, operating commercial aircraft, and conducting lawful public fireworks displays in appropriate urban settings, as held in Tom's v. Calvary Assembly of God. Scope of risk rule. Strict liability covers only harms flowing from the precise hazard that makes the activity dangerous. In blasting, liability covers flying debris or concussions, but does not extend to distant mink farm losses triggered by blasting noise. MBE application and exam tips. When a defendant transports volatile toxic chemicals with extreme care and an unforeseen collision causes a leak, strict liability applies because bulk chemical transport involves unavoidable catastrophic risks. However, if a truck transporting dynamite suffers a flat tire and crashes into a structure without detonating, strict liability fails because the injury arose from a standard traffic collision rather than an explosion. Common usage serves as a complete defense. The judge determines whether an activity is abnormally dangerous as a question of law. Attack statements. A party engaging in an abnormally dangerous activity is strictly liable for harm proximately caused by the inherent risks of the activity, regardless of the precautions taken. Strict liability for abnormally dangerous activities is limited strictly to harms resulting from the precise risk that rendered the activity hazardous. Part 4. Strict liability for products. Black-letter law. A commercial seller who places a defective, unreasonably dangerous product into the stream of commerce is strictly liable for physical injuries or property damage suffered by foreseeable users or bystanders, provided the product reached the user without substantial alteration. Core elements. Commercial seller status. The defendant is a manufacturer, wholesaler, distributor, or retailer engaged in selling the product line. Defective condition. The product contained a defect rendering it unreasonably dangerous when leaving defendant's control. Causation. The defect served as the factual and proximate cause of the plaintiff's injury. Absence of alteration. The product reached the user without substantial change in condition. Recognizable damages. Physical personal injury or property damage occurred. Pure economic loss is unrecoverable in strict tort liability. Free product defect theories. Manufacturing defect. The individual unit departs from its intended design or manufacturing specifications due to an assembly flaw, such as an exploding carbonated bottle in Lee versus Crookston Coca-Cola Bottling Company. Design defect. The product matches intended design specifications, but the entire product line creates an unreasonable hazard. Evaluated under the Consumer Expectations Test or the Risk Utility Test, requiring proof of a feasible reasonable alternative design, as in Barker versus Lull Engineering Company and Evans versus Lorillard Tobacco Company. Warning defect. Failure to warn the product lacks clear instructions or warnings regarding non-obvious dangers foreseeable to the commercial manufacturer. Warranty and misrepresentation claims. Strict liability for misrepresentation. Commercial sellers face strict liability for physical harm caused by justifiable reliance on material factual misrepresentations regarding product safety. Express warranty. UCC Section 2 to 313 affirmations of fact, descriptions, or promises made by a seller that become part of the basis of the bargain create enforceable guarantees. Implied warranty of merchantability. UCC Section 2 to 314 merchants warrant that goods are reasonably fit for the ordinary purposes for which such goods are used. A product may pass strict liability risk utility testing, yet still breach merchantability if marketed for improper ordinary uses, as held in Denny versus Ford Motor Company. Implied warranty of fitness for a particular purpose. UCC Section 2 to 315 applies when a buyer relies on a seller's specialized expertise to select goods for a known specific purpose, as in Catania versus Brown. MBE application and exam tips. Commercial entities across the distribution chain, including retailers, face strict liability even if blameless in creating the defect. Casual sellers, such as a neighbor selling a used vehicle, are exempt from strict products liability. Purely economic losses, such as repair costs or lost business revenue, require contract or warranty actions rather than strict tort claims. Attack statements. Commercial suppliers throughout the distribution chain are strictly liable for injuries caused by a product sold in a defective, unreasonably dangerous condition. A design defect exists when the risks inherent in a product design outweigh its utility, provided a safer, reasonable alternative design was technologically and economically feasible. Part 5. Defenses to strict liability. Black-letter law. Assumption of risk and unforeseeable product misuse serve as complete defenses to strict liability. Modern comparative fault rules reduce a plaintiff's financial recovery proportionally when plaintiff's negligence contributes to the harm. Defense elements and application. Assumption of risk applies when the plaintiff knew of the specific hazard created by the animal, activity, or product defect and voluntarily elected to encounter it. Comparative fault. Modern rules reduce plaintiff recovery proportionally when ordinary negligence, such as failing to inspect a product, contributes to the injury. Unforeseeable product misuse. Bizarre or unexpected misuse that a manufacturer could not reasonably anticipate cuts off liability completely. Substantial alteration. Unforeseen modifications made after commercial distribution cut off proximate cause if the modification caused the injury. Jurisdictional comparison of defenses. Ordinary contributory negligence. Traditional common law rule, no defense, does not bar recovery. Modern majority rule reduces recovery proportionally under comparative fault. Assumption of risk. Traditional common law rule, complete bar to recovery. Modern majority rule, merged into comparative fault or acts as a complete bar. Unforeseeable misuse. Traditional common law rule, complete bar to recovery. Modern majority rule, complete bar to recovery. Foreseeable misuse. Traditional common law rule, liability maintained. Sellers must design around or warn against foreseeable misuse. Modern majority rule, recovery reduced if the user acted negligently. Attack statements. Assumption of risk is a defense to strict liability when the plaintiff actually knew of the specific hazard and voluntarily elected to encounter it. Unforeseeable product misuse or substantial post-distribution alteration relieves a commercial seller of strict liability by severing proximate causation. Part 6. How to approach and write a strict liability essay. Essay analysis order. Determine cause of action category. Classify the scenario under animals, abnormally dangerous activities, or commercial products. Establish prima facie claim. State the rule of strict legal responsibility without requiring proof of fault or lack of due care. Classify subject matter. Categorize the specific entity, wild animal, domestic animal with known propensities, abnormally dangerous activity, or product defect type. Analyze specific theories of liability. On product prompts, analyze strict liability in tort, negligence, and UCC warranty claims side by side. Evaluate causation and scope of risk. Confirm actual cause and proximate cause within the zone of risk inherent in the activity or defect. Apply affirmative defenses. Address every potential defense, including assumption of risk, misuse, alteration, and comparative fault. Conclude with financial allocation. State final liability and monetary apportionment across parties. Part 7. Model essay template and framework. Memorize. Ready-to-use products liability essay outline. 1. Strict products liability, SPL. Rule. A commercial seller in the distribution chain is strictly liable when a defective, unreasonably dangerous product causes personal injury or property damage during foreseeable use. Analysis. Commercial seller. Defendant was a manufacturer/wholesaler/retailer engaged in selling product. Defect at sale. The product contained a manufacturing/design/warning defect when it left defendant's control without substantial alteration because facts. Causation and damages. The defect actually and proximately caused plaintiff to suffer physical injury/property damage during foreseeable use/misuse. Conclusion. Therefore, the defendant is not strictly liable under SPL. 2. Negligence. Rule. A commercial supplier is negligent if it breaches its duty of reasonable care in designing, manufacturing, inspecting, testing, or warning about a product, proximately causing foreseeable harm. Analysis. Defendant failed to act as a reasonably prudent commercial supplier by omitting reasonable safety inspections, testing protocols, or warnings. Conclusion. Therefore, the defendant is not liable for product negligence. 3. Breach of warranty, UCC. Rule. Commercial merchants warrant that goods conform to express factual statements, UCC Section 2 to 313, are fit for ordinary intended purposes, UCC Section 2 to 314, and are fit for specific buyer purposes relied upon by the buyer, UCC Section 2 to 315. Analysis. Here, defendant breached express promises or implied warranties of merchantability or fitness for a particular purpose. Conclusion. Therefore, the defendant is not liable for breach of warranty. Final conclusion. Therefore, the defendant is liable under SPL/negligence/warranty, subject to defenses/apportionment. 4. Defenses and conclusion. Rule. Evaluate assumption of risk, unforeseeable misuse, substantial alteration, and comparative fault apportionment. Conclusion. Therefore, then state ultimate liability and monetary recovery allocation across all parties.